Why, yes, I absolutely can. But before I do, I'm Kristen Roberts, award-winning intellectual property attorney and law firm owner here in San Diego, California. Copyright and trademark are two different things. Copyright protects original works of authorship that are fixed in a tangible medium. What do I mean by that? I mean things like movie treatments, scripts, videos, film, art, sculptures, sound recordings, handbooks, workbooks, guidebooks, books, regular books, anything that is fixed, anything that you create and you have to write it down, get it out of your brain. So basically it doesn't protect ideas. Copyright also doesn't cover things like short phrases or words, catchphrases, that kind of stuff. Trademarks, on the other hand, are actually a consumer protection method. They are invented or exist to prevent consumer confusion in the marketplace. So what do I mean by that? Well, generally speaking, the USPTO, which is the United States Patent and Trademark Office, they're the government agency that's responsible for overseeing and allowing all trademarks to be registered that are federally protected through all 50 states here in the United States. They treat consumers as though they are stupid. Meaning, if you go into a store and you see two products on the shelf and they have a similar name, you're likely to think they come from the same source. Trademarks are source identifiers. They identify the source of goods and services to consumers. So it can be anything that identifies the source of a good or a service. That can be a sound, a color, a smell. So when you walk into a store and you see that thing, you automatically go, oh, that's that company that puts that brand out. So generally speaking, trademark infringement occurs where there is consumer confusion or a likelihood of consumer confusion that's created by a competing brand stepping into the territory of the limited monopoly that is owned by the trademark holder. Copyright is a bundle of rights, and I've talked about this in a prior video, so go watch that if you haven't already seen it. But that bundle of rights gives you certain exclusive rights as the copyright holder to exploit your copyrighted material. What do I mean by exploitation? I mean money. You are allowed to make money off your copyrighted works. When somebody without authorization takes one of those rights that you are entitled to exploit as the copyright holder, they are in fact committing copyright infringement. So what do I mean by that? Well, let's look at an example. Let's say you've created a painting and you sell that painting to somebody. Selling the painting to somebody does not give them the rights that you own as the copyright holder. All they are given is the right to display it in their own house. And unless you've signed an agreement to the contrary, they can't just go out and start making 5,000 prints and then selling them on their own. That would be the right to distribute and the right to create copies, which is your right as the copyright holder. So trademark infringement has to do with infringing brand rights, and copyright infringement has to do with infringing certain bundles of rights that we talked about before. Follow for more and let me know if you have any questions.